I want to welcome everyone to today's webinar. My name is Kathy Brown, and I am the Community and Economic Development Educator with the University of Illinois Extension. Today's webinar is being recorded, as we've talked about with each of you, and we're doing that so that what we're finding is that our live participation numbers and our recorded participation numbers are almost equal. So it's a really valuable service when we can to record the program. And in order to do that, we do need to minimize the background noise. Even my microphone will be muted after I give this really brief introduction. We want to encourage you to use the chat space, though, because we do want this to be an interactive presentation. So if you're listening to this online, do look to that chat space to enter your questions. The presenter may deal with them in the course of the presentation, or we may bring them up towards the end of today's program. But today's program is really part of the University of Illinois Extension's overall comprehensive programming. And we strive to do programming in a way that addresses a variety of new needs and provides equal opportunities in programs and employment. And if you know of individuals who need accommodations to participate in programs, please do reach out to your local extension office, and we will work with you to make that possible. As a University of Illinois Extension program, it's really important that our team, today's program is made possible through a partnership with other community and economic development educators, that we want to hear from you. It helps to guide and shape our programming direction. So there will be at the end of the program, we will be sending out an email to everyone who registered, and you'll be encouraged in that email correspondence to give us feedback. And we really do value that and appreciate it in helping to shape program direction. Today, our speaker is Taylor Anderson. He's a full-time registered contractual lobbyist in the state of Illinois, and he spent nearly a decade working with the Illinois General Assembly. He's lobbied on behalf of a wide and diverse group of clients, including various councils of governments, individual local governments, as well as numerous business entities and corporations. Taylor began his legislative training by interning at several state agencies, including the Secretary of State, Jesse White's office, the Illinois Senate President Emil Jones Revenue Committee, and the Illinois Environmental Protection Agency Legislative Affairs Division. He, as the Dunn Fellowship, serving the legislative office of the governor, where he has helped to design and author legislation. Prior to lobbying, Taylor worked with the Illinois Chamber of Commerce, Government Affairs Division, and he researched and authored chamber position papers. And he's also worked with the Illinois Association of County Board Members and Commissioners in organizing seminars and various media forums and publications. At this time, I want to welcome Taylor to our program and turn the program over to him. Thank you, Taylor.
Thank everyone for joining us. I know we got started a little late, so I'll try to speed up the presentation so we can still get everyone out of here by 1. Thank you for calling in, and thank you for the University of Illinois Extension for putting on this seminar so we can talk and discuss the legislative issues that transpired during the 2017 session year, and talk a little bit about what we anticipate happening for this upcoming spring session. So with that, we'll start the presentation. During the 5 months that the Illinois General Assembly was in 2017, the state lawmakers passed about 615 bills, of which 573 became law. We're looking to return to session this year, starting January 23rd, and the Senate coming in on January 30th. An important date to keep in mind is the governor is set to give his State of the State address on January 31st, and the all-important budget address will be given on February 14th, Valentine's Day. So hopefully he'll have nice things to say about our state, considering the date. We'll skip these dates, but if you'd like to look, the next couple slides have some important and key dates that will transpire over the spring session, with the adjournment set, as it always is, for May 31st. Obviously, in 2017, spring session went a little longer as the state tried to put a budget package together, and luckily we were able to, but that didn't take place until July 4th. And so as you can see, sometimes even though we are set to adjourn on May 31st, we don't always quite make that goal. Moving forward, we'll talk about some of the key pieces of legislation that were passed and signed by the governor this past year, and then we're going to talk a little bit about 3 bills actually that were introduced last year and for one reason or the other didn't quite make it to the governor's desk to be signed into law, but these are issues that we think we'll see again this upcoming year. With that said, we'll start off with, I'm sure as everyone on the phone is aware of, the governor and the lieutenant governor formed a local government consolidation task force, which also focused on unfunded mandates. Out of that task force, a number of reports, or excuse me, a report was submitted to the General Assembly, and in that report, a number of actions were requested to be made by the General Assembly. 2 bills, Senate Bill 3 and House Bill 607, reflect some of the recommendations that that report contained, which was made by the task force chaired by the lieutenant governor. So we'll talk a little bit about Senate Bill 3, which is now Public Act 107, and House Bill 607, which is now Public Act 106. These both deal with consolidation and elimination of different units of local government. Public Act 100-106 deals with abolishing road districts. It amends the highway code and allows that, again, this starts at the Board of Trustees, so the township board will be able to decide that they'd like to consolidate and abolish the road district, and then the township board would then decide how they would fulfill the responsibilities that were traditionally carried out by the road district. So, for instance, they may try to contract with a municipality or a county to maintain the roads that the road district used to oversee. Obviously, this is part of the movement, as I mentioned before, obviously with the task force, but the movement to consolidate the wide number of units of local government that Illinois has. It's been in the papers and obviously on the news. It has done several reports about it, but this is keeping in vein with trying to bring that number down. Again, there was some concerns, I think, from the county side with regards to making sure that this was done in a cost-effective way. There is considerable cost when you talk about maintaining roads, and I haven't spoke to any county engineers or county board members who are excited, we'll say, about the prospect of maintaining more roads. But again, this is something that would be started at the township board level, and then they would be responsible for maintaining those roads. How they maintain those roads would be up to them, but certainly we foresee some circumstances where they would maybe, if this were to be implemented, maybe contract out with either a third party or perhaps another unit of local government, like I said, a municipality or county. I should say that this is already in place. This was signed, and so this affects excuse me, all of the counties. Cook County already enjoyed this power, or townships in Cook County already enjoyed this power previous to this bill becoming law. The next bill, or Public Act, which was Senate Bill 3, is now Public Act 100-107, deals with a little more expansive language with regards to consolidation. Several years ago, DuPage County underwent an initiative and was able to pass it through the General Assembly, which granted the county board large powers with regards to units of local government within the boundaries of DuPage County to consolidate or to eliminate those various units of local government to try to bring the number of units of local government within DuPage County down and to achieve some efficiencies of scale and hopefully to reduce the cost. That is still ongoing in DuPage. In subsequent years, both Lake County and McHenry County were added to that list, and what this Public Act does is expands those powers to all 102 counties within the state. And so now there's an opportunity for any county board to look within their own borders at perhaps some of the units of local governments under them and look at potentially consolidating those units of local government, again, to achieve some more efficiencies of scale. I will point out that existing contracts that those units of local governments have, those workers have, they must be maintained. So, for instance, if you were looking at combining 2 units of local governments and each unit of local government had existing contracts with, let's say, 10 employees each, even if you were to combine those 2 units of local government together, you must still maintain the 20 workers, the 10 prospective workers each that those units of local government had. And I know talking with some county board members, really the efficiency of scale that they foresaw would be to eliminate duplicative roles. But however, I just want to point out and hope everyone bears in mind that existing contracts must be maintained. And so after those contracts were to expire, you might be able to look at doing something there, but you must honor those existing contracts. And that, I think that's an important point for any county board that's looking to consolidate. That's something they need to keep in mind. There wouldn't be any cost savings immediately for personnel. This bill not only dealt specifically with county boards and how they're able to consolidate or eliminate units of local government within their boundaries. This also specifically dealt with allowing townships to consolidate with coterminous municipalities, allowing townships to consolidate with other townships, or townships allowing being able to be eliminated or abolished. Again, this bill also prescribes very direct and detailed procedures for how those rights and powers, duties, assets, and properties, and also liability would be transferred. So, for instance, if 2 townships were going to be consolidated, the new township would pick up all of the obligations, the liabilities, outstanding debt, assets, and property from the 2 eliminated or merging townships. So again, I want to make sure everyone is well aware of, although we're looking at consolidating or even potentially eliminating units of local government, the assets and the obligations that unit of local government has, they don't go away. They would just be transferred. And so on some hand, this might make sense. On the other hand, we could see some areas where, not much would change if a township were to be eliminated, because those obligations and liabilities would still exist. So again, I just want to make sure everyone is aware of some of these things, that are going to be more on the back end as you think about whether or not this makes sense for your particular community. That also prescribes in a very detailed manner how those referendums would take place and the steps needed to put a referendum on the ballot. I will say, similar to what we discussed with the county boards, taking over authority, this for the townships also starts at the township board. That conversation to hold a referendum begins at the township board. So the township board would elect to either consolidate with a coterminous municipality or with another township before that referendum would be placed on the ballot and allowed for voters to have a say. We'll move to Public Act 100, 554. Obviously, last year, at the tail end of last year, with the news of Harvey Weinstein breaking and all the subsequent news stories, certainly politics has not gone through unscathed. And so we've seen a number of sexual harassment scandals and stories break across the nation, and Illinois is no different. We've had some here, and in order to combat that, a bill was quickly introduced, passed by both chambers, and signed into law, and now we have this law on the books. Essentially, and the important thing that I believe everyone on this phone call should be made aware of is the steps that you have to take as a county board. All counties, and indeed all units of local government, must adopt an ordinance or a resolution establishing a policy prohibiting sexual harassment, and that needs to be done prior to January 15th. Again, this bill was passed very quickly. We at the Association of County Board Members tried to get the information out to everyone, make sure they were aware of it, and provided a model ordinance and policy that you could adopt or use as a blueprint to create your own. But again, those ordinances need to be adopted before January 15th, and they must explicitly prohibit sexual harassment. A lot of the HR policies and things that were on book are on hand before. Those aren't going to be enough. You have to actually adopt an ordinance, again, that we've outlined in our model ordinance that you all should have received. If you have not received that, please let us know. At the end of the slide, there's some contact information. We can get a hold of Kelly Murray, who's the executive director for the association. But again, this is something that's very important. Obviously, this is something that the media is paying very close attention to, this issue. And so we just want to make sure that everyone is following the rule of law and gets this ordinance or resolution adopted before the date. The next bill, or the next Public Act 100, 553, is in the same vein of the Public Act we just discussed. As I mentioned, there have been a couple of cases, or several cases, I should say, of complaints, allegations of sexual harassment in the General Assembly at the Capitol building in Springfield. And there was a big problem with the fact that these complaints had not been properly reviewed because the state did not have a legislative inspector general for a year, and there was a year restriction on all complaints, and so there was a worry that a complaint that had maybe been filed while we didn't have an inspector general, its time would be up before we had a new inspector general in place. And I'm happy to say we do now have an inspector general at the Capitol building, and this bill just waives that one-year restriction so that complaints that were raised but hadn't been taken up due to the fact that there was no inspector general dating all the way back to December of 2014 can now be investigated. And there are a couple investigations going on right now currently. But again, this issue, as we've tried to make sure people are aware of, isn't going away. This is something where we're seeing a lot of scrutiny on it, which is good. We just want to make sure that that you all are following the rule of law. And again, this bill doesn't directly impact any of any of the folks on the phone right now. But as these complaints are being investigated, we do anticipate there being some rulings on whether or not these complaints had merit, and whether or not a person and potentially a legislator violated law and did commit sexual harassment. And we do anticipate there being some changeover with legislators. We know that there was a senator from the northern region of the state who had allegations very publicly made against him, and is right now, it doesn't look like he's going to be able to run again. And we do anticipate some more of these complaints resulting in potential resignations or stepping down of state legislators. And so this is something that we're keeping close track of, as this could affect your local legislators. The next bill is Public Act 100-433. Excuse me. This was an issue. This issue affects the entire state, but it affects some counties more than others, depending on whether or not you have an active and robust electronic recycling system in place. As you may or may not be aware of, Illinois is one of many states that has electronic dumping ban, meaning certain TVs and certain electronics can't be thrown in the trash and be landfilled. There's a landfill ban on them, particularly the CRT TVs. These are the old, the old TVs that everyone had when I was growing up, at least, that contain lead inside of the TVs, which is why they're banned from being placed in a landfill. But there's also other bans on electronic devices. And so what we had been working on for the last 4 or so years is updating and modernizing how our electronics recycling worked in the state of Illinois, and to hopefully make it easier for counties to, if they chose to have electronic recycling program within their county, and to do so at a very cost-efficient way. Again, that has been one of the hindrances, I think, for a number of counties having a recycling program is the fact that it's just been cost prohibitive. So what this bill did is we've changed the old standard. We've moved away from how we used to recycle electronics, and we've moved to what's known as a convenience standard. And what that means is, if your county opts into this consumer electronics recycling program, anything you collect will be recycled. Before, there was some, it was done by weights. It was weight-based. And if you collected more, if you collected too much weight, then not everything would be recycled. And as I've said, we've moved away from that, because that kind of places a ceiling on recycling. And so we're going to the convenience standard, and that means anything that is recycled will be recycled. In order to do that, we had to establish or create what's known as a manufacturer's clearinghouse. And what that means is the manufacturer's electronics, your Sonys, your HPs, your Dells, your TV and computer manufacturers, they're going to get together, establish this clearinghouse, and they're going to help. They're going to be partners with any of these local recycling centers and recycling programs that are set up. Our hope is that we can establish more recycling programs throughout the state. For those who are able and want to, there's an opt-in provision. So no county will be forced to set up a recycling program. It's all permissive. If you want to do so, you can. And we also added in this bill language that allows for third-party or consumer groups to have their own recycling programs and charge a fee for. So that was a big issue. Best Buy now, it's typically had a recycling program where you could take your old TV or your old computer to Best Buy, you pay them 15, 20 bucks, and they recycle it for you. We've made sure that we've kept that in place, so Best Buy and Goodwill and others will still have their own recycling programs. But if you'd like to partner with them, or if the county would like to have, maybe a one-day recycling program event where everyone from within the county can come in and drop off, however many TVs, however many computers, or et cetera that they'd like to, you will be able to do that, and you'll be partnered with the manufacturer's clearinghouse. This next slide is just a continuation of that, and it gives what is the important date. March 1st of 2018, any county interested in joining and opting into this clearinghouse has to do so by that date. Again, that date is for a year, so let's say, in 2019 or 2020, you say, well, maybe this is something we want to do. You can still opt in at later dates. When you opt in, you're only opting in for a year. One of the things that we had to trade off in order to do this, however, was to limit the number of collection sites allowed based on population. And that was a trade-off that we had to negotiate with the manufacturers of electronics. But again, I think it's a fair trade-off considering what we're trying to do and the new system we're trying to create. Again, the goal is to, because there is a landfill ban, and I know not everyone follows the landfill ban, and I wasn't myself even aware of the landfill ban until 5-6 years ago. So obviously the education needs to be better, and that's one of the things we're going to be partnering with the Illinois EPA on. But the goal is to try to make sure that we're being responsible in recycling these products because of the detrimental effect that they can have on the environment. Again, this is just opt-in. If you'd like more information about that, please contact Kelly or myself. We're more than happy to talk with you about this. One of the nice things about this program is when you opt in, you don't even have to actually do the collection yourself. You can partner with a Best Buy, you can partner with a Goodwill, or you can partner with a good government group or something like that. So you don't even have to staff or maintain the collection day yourself. You can have someone else do that for you. But again, it's very new. We understand there's going to be a lot of questions about it, and so I just wanted to make sure everyone's aware of this. If you have more questions, please feel free to contact Kelly or myself. The next slide deals with the trailer bill to the bill we just talked about. The trailer bill doesn't really affect anyone on this call. This was cleanup language for the EPA. There was some cleanup language for the industry groups to make it a little easier for them to set up the clearinghouse. But it also required some changes in law so the EPA could better keep records and have some reporting requirements for how much material, how much of the electronic devices are being collected. But again, it doesn't really change anything for how the program works at the county level. This was just a trailer bill to make it a little easier to actually implement the program. We have been following this bill or this idea of the bill for the past 4 years, as I said earlier. So obviously we wanted to just make sure we were included in conversations and talks on the trailer bill. We do anticipate there being potentially another trailer bill coming forward during this spring session. As with anything, anytime you kind of create a new law or create a new system, there's going to be bugs, there's going to be kinks, and so we do anticipate some more trailer bills as we try to work all the kinks out of this new system that we've kind of created and set up. But again, we expect that trailer bill to be something that's agreed to by all parties, and hopefully will make the system stronger and easier for everyone to use and to appreciate. The next bill was a bill that we started out the year opposing. We were able to work with the proponents of the bill and reach a solution that allowed us to remove our opposition and for this bill to be passed by both chambers and the General Assembly and ultimately signed by the governor. Before I get into actually what the bill does, I want to give just a little background. There was a court case in Cook County that kind of necessitated the change or necessitated the need for this bill. That court case, or the decision that derived from that court case, threw out existing statute and created an environment that the proponents of this bill had some severe concerns with. And so what this bill sought to do was to, I won't say turn back the clock, but to reestablish the status quo. And at the beginning, the bill went a little too far and changed the landscape a little too much. And what we ultimately were able to do was to make sure that it was understood that although this court case happened in Cook County and changed the landscape for Cook County, that the law that the rest of the counties, the other 101 counties, had been operating under didn't see any change. So basically what we have here is this allows a county with a population of less than 2 million, again, carving out Cook because of that, the court case, they're going to be treated differently. It allows those counties to adopt an ordinance or resolution with certain exceptions that require the issuance of a permit that impose regulations upon the operation of a solid waste landfill, a sanitary landfill, storage site, transfer station, waste disposal site, and others. And basically, again, there will be no changes to how you issued those permits before. We were just clarifying that the Cook County case, and essentially what the Cook County case said is that every county could have their own law. They tried to essentially do away with the provisions and enumerated under the Environmental Protection Act for how these landfill, sanitary, storage sites and transfer stations would be regulated. And if Cook County wants to do that, we think that's fine. The problem is that right now all of those sites are regulated under the Illinois EPA, and the concern is that each county would start adopting their own plan. And most of the counties, when we sat down and we talked to counties, we understood that we're fine with letting the EPA do that. Most of the counties in the state, don't have the personnel to get into the regulation business on solid waste landfill units and landfill storage sites, etc. We still wanted to have our ability and our authority to issue those permits and to make sure that they're, again, as I said, there's certain exemptions that, we won't be able to issue guidelines for, but again, that was already understood in previous. So basically, we had to do this bill to make sure that the status quo remained the same. I'm happy that we're able to reach an agreement, and basically, it's a long bill, and that was a long spiel to say that nothing's changed on this topic, so don't worry about it. But sometimes, we have to go through the motions and work to make sure that the apple cart isn't overturned when we have kind of these one-off court cases. The next bill is obviously a very important bill. It's Public Act 120. This deals with 911 emergency funding. As you know, every couple of years, the Emergency Telephone Act sunsets, and therefore that sunset needs to be extended for another couple of years. What happened in this case is that we had a bill that passed the General Assembly and was sent to the governor, and the governor decided to veto that bill because the measure authorizes that the city of Chicago can have an increase in the surcharge that they have on phone service contracts. Well, that threw the rest of the state up in the air as well, because the governor didn't just veto for the city of Chicago, he vetoed the entire bill. So the General Assembly came back, passed another bill, which the governor then again vetoed. And so it took an override, a bipartisan override in both the House and the Senate to make sure that this bill became law. Again, this is very important. Without this, our E911 kind of goes away. It would sunset the Emergency Telephone Act, which is obviously, it would be very difficult to explain to voters and to people that live in the state of Illinois why 911 doesn't work. So we were happy that this bill was overridden and is now law. I mentioned the city of Chicago's increase on their surcharge. There was also a provision that allowed an increase for other units of local government throughout the state, so all other counties. And we had an increase in some other areas. As more and more people move away from landlines, it's important that we realize that landlines, that the original 911 system was built on the back of the surcharges on landlines. As people move away from landlines into cell phone and wireless, it's important that we recognize that and try to put more money into the program from other places. And one of the things that was included, as I was saying, was an increase on our surcharge in the rest of the state from 87 cents to $1.50 starting January 1. So that's already gone into effect. The next bill we'll talk about deals with legal notices. This deals with a long-standing push by our association and others to try to reduce costs on units of local government with regards to publishing in newspapers. Obviously, the things that we're required to put in newspapers can add up when we have to do them several times a year. And so we've been trying to find some cost savings on that end, as well as the fact that more and more people are getting their information from the web, and newspapers are kind of following landlines as people move less from the printed page and start getting their news from their screens. So what this bill allows for is it gives a unit of local government and school districts the ability to use a secular newspaper that has general circulation within that local government and that would still fulfill the requirements under the Public Act notice requirements. Previously, what the Act stated is that a newspaper, in order to qualify or to be a qualifying newspaper, that newspaper had to be published in the county in which the unit of local government or school district is located, or in an adjoining county. And what we were finding is that in some cases, for whatever reasons, financial reasons, they didn't have readership. The normal or the old newspaper that these notices were being published in had either closed or were no longer circulating in a given area. And so we were having newspaper or notice requirements being placed in newspapers that didn't even have circulation within a given unit of local government. And so this, again, is just part of that idea that we're trying to modernize these notice requirements as they deal with newspapers. I think we're going to see this trend continue, as I said, as the newspaper industry shifts and media shifts to more and more online content. The requirement to publish in newspapers just is starting to see a little more and more archaic as technology continues to advance. And so, again, this would allow for you to publish in a newspaper that it doesn't have to be actually in your county. It's the newspaper that has circulation or has the most circulation within your county. So we think that that's better. It's actually giving the information to the people within that unit of local government who are getting that particular newspaper there. It's not tied to actually a specific location of where that newspaper is printed. The next bill, excuse me, deals with recorder fee schedules. We've seen more and more focus on fees at the local level. The General Assembly is starting to look at fees, and sometimes that's good, sometimes that's bad. Sometimes we have fees that haven't been raised or adjusted in 20, 25 years, and sometimes we have fees that the General Assembly feel are a little too high, and so they try to bring those fees down. This one kind of falls into the latter category. It requires that counties adopt and implement a predictable fee schedule by January 1st of 2019. So you're going to have to be working with your clerks to look at your fee schedule so you can adopt as a county board a more predictable fee schedule. Schedules shall eliminate surcharges or fees based on individuals' attributes of a standard document to be recorded, and sets out a flat recorded fee allowable for each classification of standard documents. So again, as I said, sometimes it's good when the General Assembly looks at fees for us because we're increasing or raising a fee that maybe hasn't kept pace with inflation, and sometimes they're looking to lower or reduce fees. Again, this is something that you're going to have to do by January 1st. So please be working with your clerks and your recorders to make sure that you've adopted what is going to be considered a predictable fee schedule, and you have to do that by January 1st of 2019. Now we're going to talk about a couple of bills, or a few bills, I should say, which made their way through the General Assembly or were introduced last year, but for one reason or another didn't quite get to the governor's desk and didn't receive a signature. But we feel that these are issues that have the potential to come back. And the first is an issue that we dealt with in this past veto session in late October, early November. And we think this issue is not going away. We saw several property tax freeze bills introduced last year and the year before. It's an election year this year, and this issue polls very well with voters, and so we don't think this issue is going to go away. And we want to make sure everyone's aware of that fact. What this property tax bill sought to do was a little different than what we had seen in years past. Normally, a property tax freeze bill just set a standard of either a 2-year or 4-year or even a permanent property tax freeze for the entire state. What this bill did was a little different. It mandated a 2-year freeze on Cook County and the Collier counties, and then it allowed county boards in the rest of the state to put a referendum on the ballot asking their voters if they should do a property tax freeze. And so it kind of split the state up a little bit, where you could have some counties who would have a property tax freeze right next to counties who did not. And so that was a little different. It was a little, just the first time we'd ever seen anything like that. I think one of the really important differences of this bill, other than what I just mentioned, was the fact that this sought not only to do a property tax freeze, but also looked at increasing homestead exemptions, both on individual homesteads and for senior citizens, increasing the rest of the state up to the Cook County dollar amount. And so, on one hand, you could be potentially looking at a property tax freeze, and on the other hand, you could be looking at a reduction in your levy base, and actually see folks, even if you had a freeze, actually see folks see their property tax bill go up as the levy sought to fill in, the holes created by these exemptions. So it was, as I said, it's a very unique strategy. We hadn't seen anything quite like Senate Bill 851 before, and I don't think we're done seeing kind of these innovative new approaches to trying to do a property tax freeze moving forward. I think we're going to see some more property tax freeze bills introduced. This bill passed the House on a vote of 75 to 32, and so that is a veto-proof supermajority. However, the bill didn't advance in the Senate during veto session, and so we think we're probably going to see a new bill introduced. We don't think Senate Bill 851 is likely to move again, but you never know. It still has the possibility of moving during this upcoming spring session. But it's something to be mindful of. We had a couple of counties look at what this would do to their levies and especially what the increases in the homestead exemption and the senior citizen exemption would do to to their bottom lines, and it was quite devastating for a number of counties. And so, if this is something you haven't done or something you haven't looked at, please do so, because we do think these issues and these topics aren't going anywhere. We're going to see them again. The next bill is Senate Bill 1451. This is the Small Wireless Facilities Act. Essentially, this allows wireless or telecommunication companies to have access onto your towers, onto your poles and rights of ways to place these small wireless facilities. This is somewhat different than your typical towers, because these are small wireless facility devices, and these are mostly going to be used for data. For handheld devices, your cell phones and your iPads and the like. So this bill, we had negotiations with the telecommunication companies on this. The counties were able to come to an agreement with them. So this was led by several of the larger counties: DuPage, Lake, Cook, and others. Will County also, they had a lot of concerns about this. This bill did pass both the House and the Senate, but a motion to reconsider the vote was filed by President John Cullerton. It's my understanding that there might be some more talks down the line, so certainly this is going to be something that we pay attention to and sit in on those conversations as they move forward, because this bill changes the way that your zoning works with regards to the placement of these small wireless facilities. Again, these are going to be they're called small wireless facilities, but they can still be quite large in diameter, and they're going to be basically removed from the zoning process and be considered a permitted use, which is a different process, and will limit your ability to control where these go and on what poles telecommunication companies can place them on. But again, right now, this bill hasn't been sent to the governor's desk, as there's more work likely to be done on it. Real quick, on House Bill 278, this is the Local Government Distributive Fund bill. As everyone's aware of, back in 2010, when we did the first income tax increase, the LGDF was lowered. We still received the same amount, but it was lowered from 10% down to 6%. It's now moved back up, and it will keep moving back up. And on 2020, we should get a little closer to that 10% that we've always traditionally been at for LGDF. This bill sought to move that time frame up and get us closer to the 10% much sooner. That's more important now than ever, as the income tax increase has become permanent. The numbers of dollars that aren't going back to the communities where they should be going to is going to be huge, and has been huge over the years as we've lost out on these LGDF dollars. But this bill passed the House, which we are very happy to see. Got stalled in the Senate, but we do anticipate this bill being revived, and hopefully we can get it through the House again, and hopefully through the Senate and onto the governor's desk, because this issue is very important. I know we started late, and so we're closing to getting close to 1 o'clock, or we're at 1 o'clock now. I'll just briefly talk about these next two bills and then open it up to any potential questions there are. House Bill 678 and Senate Bill 1799, which I just changed the slide to, both deal with the same topic. I'm going to switch back to the House Bill so we can talk about that. But House Bill 678 is an initiative that we opposed because of the fiscal restraints that this would place and the cost that this would have on counties. This bill, as it was introduced, tried to mandate that a juvenile be brought before a judicial officer within 24 hours rather than the 40 hours that we currently have. And what that would mean is you would have to have the courts open every single day, Saturday and on Sunday and on holidays. What they're not understanding, the proponents of this bill, is that juveniles are a little different than, or they're much different than adults in regards to the number of people that have to be and attend these hearings, the security measures that have to be in place, and with regards to the fact that not every county has a juvenile detention facility. In fact, there's only 13 or 14 in the entire state. And so transportating juveniles between a juvenile detention facility and the county where the hearing would also be an additional burden. We've been working on this bill for a number of years. We anticipate this bill to be filed again, and we anticipate to continue to have conversations and discussions related to this issue. Again, our point has always been, we want to do what's best for the juvenile. At the same time, we also have to keep in mind the logistics and the financial realities of trying to do a 24-hour judicial hearing for juveniles. The Senate bill, which I just changed the slide to and showed before, Senate Bill 1799, was our preferred method at a compromise. We passed this out of the Senate. The House sponsor of the other bill picked this Senate bill up so we could continue to have conversations. But this is what we thought would be a more fair, a more equitable, and also quite frankly, a more doable alternative to 24 hours. So again, with that said, that's the last bill. We do anticipate that conversation to continue to happen, and we will keep everyone informed as those move forward. At this time, and I apologize that we ran a little over, but at this time I'll take any questions if there are any. If not, if you don't have any right now, the slide you'll see is if you have any questions that you thought of afterwards, or you want more information, please contact Kelly Murray, and there's her information.
Thank you, Taylor. I think you presented a lot of really interesting facts here for counties to consider, and certainly things to watch as we move forward throughout the year. And I do know that the Illinois Association of County Board Members is a great resource, not only in watching legislation, but helping county governments to deal with these issues that are being presented in legislation. I want to say thank you very much for being with us today, and a really great presentation and working through the technical issues that were present at the beginning. So thank you for being with us and your patience in dealing with that. I want to let everybody that's still on the call know that we'll be back next week, and the National Association of Counties will discuss federal legislative changes that have occurred or are in the works, just like we did today, and that will have a direct impact on Illinois local governments for the coming year. If you registered for today's program, you should get a notice, a reminder about next week's program. If you have other folks that you'd like to have join in for that national presentation, we would still accept those registration. And Nancy, you may want to put up the polling slide just to get a little bit of feedback about today. But do know that you can also follow extension on our local government education website, and you can view past program recordings, and you'll find links to all those programs that will take you directly to a YouTube channel. So I'd ask if you're still on the call, if you'd give us some feedback on today's presentation by participating in the poll. Just to click on how the information was presented and what new knowledge that you gained as part of it, today's program. At any time, do feel free to contact your local county University of Illinois Extension office, and they can put you in touch with our presenter today, with local resources from University of Illinois that can support you in your local government work. I want to say thank you for your support, and feel free to contact us at any time. Thank you very much. Great job, Taylor.
Thank you, everyone. Have a good day.
Thank you.